In addition, the preamble should state that sanctity of life remains one of Canada's most fundamental societal principles, that it is not contrary to the public interest to express the view that participating in causing a person's death is intrinsically, morally, and legally wrong. This also means that Parliament should protect the charitable status of organizations devoted to preventing suicide, as well as religious organizations and healthcare facilities that decline to provide MAID at their facilities through clear amendments to the Income Tax Act, which we set out in our brief. These amendments will serve to promote freedom of religion, conscience, and expression, but just as importantly, respect and preserve a medical and societal culture in which treatment is promoted as a solution to suffering, not suicide. We also urge Parliament to explicitly protect the rights of those who object to participating in MAID, such as healthcare providers. And I know others will be speaking to that matter this afternoon.
Despite diverging opinions, there is a broad consensus that exists on the matter that further to the Supreme Court's decision in Carter, many measures must be taken to protect those who deliver health care and those who object to medically assisted dying because of reasons of conscience. We want to ensure that they would be available, there would be availability to that medically assisted dying, but also to palliative care. First of all, allow me to begin with the issue of the conscientious objection. Many health professionals are opposed to medically assisted dying by basing their position on their profound moral, religious, and ethical convictions. Unfortunately, Bill C14 presently is silent on the issue. And for many of them, this is an act, that is to say, medically assisted dying is something that is unacceptable. We are very encouraged by the fact that Bill C14 doesn't force doctors to directly refer their patients. Had that been the case, Canada would have been the only country to impose such a requirement, and it probably would have not met the mandate of the Supreme Court. I stress the fact that accommodations concerning the views of these professionals have to be taken into account.
Association has proposed a separate central information, counseling, and referral service to which objecting physicians could direct patients seeking physician-hastened death. Dr. Herschel Berman, a specialist in internal medicine and palliative medicine at the Temi Latner Center for Palliative Care in Toronto, and an associate professor in the Faculty of Medicine at the University of Toronto, recently proposed another model in the Hill Times. He wrote, and I quote, "Rather than actively referring patients, all physicians should be required to report any request for assisted death to the Provincial Ministry of Health or a regulatory body. Physicians would be required to register if they are willing to and qualified to provide medical assistance in dying and indicate how many additional patients they are able to take on per year. If the report is from a doctor willing to provide the service, he or she would receive confirmation. If not, the registry would connect the patient with a nearby practitioner." Dr. Berman also noted that, and I quote, "In addition to respecting the beliefs and values of physicians who object to medical assistance in dying, this process has an additional benefit. Many physicians, especially specialists, have a limited network of colleagues to whom they are accustomed to referring. In isolation, particularly in underserviced areas, any doctor may have difficulty finding a colleague willing to accept the patient. If the process is managed centrally, a registry can ensure more effective and timely access for patients who wish to hasten their own death." End of quote.
This has come up in the committee a lot from different organizations as well as colleagues around this table with respect to protecting the conscience rights of medical personnel, physicians and nurses, etc. Now, what is your opinion? I would ask this for all three of you to comment. What is your opinion on having a criminal prohibition, creating an offense in the criminal code to to make it an offense to coerce a physician into administering death under this bill.
To make it a criminal offense. To coerce a physician to. We're going to the balance of competing rights here, and those two rights were recognized by the Supreme Court in Carter. I'm not sure we need to go that far, as I do believe, as per Carter and as we suggest, that there is a way to make sure that the conscience and religious rights of medical practitioners be respected in that process. Otherwise, it wouldn't make it more legal. If those rights are not respected, this process is not legal per se, and we could go back into the whole going back to the court and take years and years and years. And I think you have the possibility in front of you, and you can craft the right balance between those two rights that a lot of Canadians are looking for. People who are for a medical assisted dying, by the way, and people who are opposed to it. If there's one place where I believe there's consensus between those two competing visions, it is those. It is this.
Mr. Bach, if you have some comments.
I think you solve the problem by going with advanced review, because then physicians aren't actually authorizing this. They're doing their job as physicians, and that's our proposal to address that concern. And it also means that you're going to have many more physicians in Canada beyond the only 1/3 that are saying they would do this at this point, that would be willing to step up, because they're not actually authorizing it. They're just examining causes of suffering and putting options on the table to address it, which is what we should be hoping and expecting of physicians in this country.
Okay. And Mr. Fletcher, if you have some remarks on that?
Yeah. In Canada, you cannot force a physician to do anything. I am aware of a physician who refused to see people who smoked. There was nothing the college could do. It was his choice. But what we have to make sure is that people are not denied their charter rights. And that is the concern I raised earlier about the Section 141B. It's not clear that people are made aware of all the options available to them. In fact, it seems that it would be against the law if they were to raise the prospect of death. And that is essentially a denial of charter rights. But nobody will force anybody in the medical profession to do anything they don't want to do. You don't have to do it now, and they'll never be able to force someone to do it. The Supreme Court was very clear.
Thank you very much, Mr. Khalid. Very good questions. Can I just clarify something that was just said, because I'm a bit confused. So there's been a lot of people from all sides of the debate, as Mr. Marceau had said, that have come forward and said that conscience rights should be protected in a way that is more clear than is currently the case, in which the preamble references somewhat of a conscience right. Ms. Khalid suggested one way that could be done through a criminal prohibition. There are other ways. You, Mr. Bach, seem to suggest that was unnecessary, provided that there was the review process, but the review process would only ascertain that the person was competent and willing, and that all of the requirements of the law were met. There would still be a physician that in the end would be there doing the act.
Right.
So in order to prevent a physician, a nurse, a pharmacist, anybody who didn't want to do that from being fired or from being coerced into doing it, the thought was to find a way to still add conscience rights. I don't understand how having that added process would change that there would be people of conscience that wouldn't want to do this.
Yeah, I wasn't suggesting that conscience rights shouldn't be protected. Conscience rights.
Okay, so I was a bit confused. Thank you.
Yeah.